Okay, everyone. Welcome to our third Facebook Live today. Thanks for tuning in. Today, we are going to speak about what we can expect from a new Trump term with respect to employment-based and legal immigration. Yesterday, we spoke about what we can expect with respect to the southern border, Trump's aiming to end birthright citizenship. We spoke about asylum seekers being required to remain in Mexico while cases are processed. I mentioned the border wall construction and the Trump administration wanting to resume and accelerate that. And overall, we chatted about some aggressive shifts in immigration policy, primarily down on the southern border and with respect to unlawful entries in the US, and how we expect to see widespread legal and political resistance. Today, we're going to chat about what we can expect regarding employment-based immigration and legal immigration. So as we dive into this topic, we're going to really explore what we can see, where we expect to see heightened focus regarding employment-based visas, which allow someone to enter the United States on a temporary basis to work for a US employer. We're really going to focus on the H-1B program today, and that's been a central focus of past immigration reforms under Trump. And we'll talk about how we expect to see potential changes on employment-based immigration directly impacting businesses, foreign talent, and even the broader US economy. So let's get started. The first item I want to chat about is where we expect to see changes on the H-1B category. First things first, we have a very recent change called the H-1B modernization rule that actually goes into effect tomorrow. This rule is being rolled out by the Biden administration, and it's fundamentally sort of reshaping how employers sponsor foreign workers, starting with the definition of specialty occupation. Generally, under the H-1B category, if an individual has a bachelor's degree, and they have an employer who wants to offer them a US job offer, they can enter the H-1B lottery, which runs on an annual basis in March. If they are selected, an employer can file a petition for them. And you generally need to prove that that candidate has a bachelor's degree or higher, or an equivalent of a US bachelor's degree, and that they are entering a specialty occupation. So the Biden administration is further defining what a specialty occupation is to tighten that up. And it's going to be interesting to see what sort of adjudication policies the Trump administration rolls out internally with respect to how officers adjudicate those applications. We expect that things may be a little bit harder. We also expect to see some pushback for third-party worksite scenarios. The new rule does require employers to provide detailed work itineraries for third-party placements, which could discourage staffing companies that rely heavily on H-1B visas. Under the Trump administration, we really do expect to see a focus on fraud and abuse prevention. So I wouldn't be surprised if H-1B sponsors see more employer site visits by government officers, namely ICE and DOS and DHS. Also, maybe the Department of Labor, DOL. So that means that employers definitely want to focus on their compliance practices with respect to keeping public access files for their H-1B workers and ensuring that the job roles, which are reported on a petition, align with the degree requirements and wage standards. If the government is walking in and doing a worksite audit for your H-1B workers, employers that are not maintaining these compliance practices can definitely expect penalties or even blacklisting from the H-1B program. So it'll be interesting to see how we see the effect of tighter practices on H-1B sponsorship under the Trump administration. The first term that Trump was in, we definitely saw tighter practices. There were some changes in terms of who would be qualified for the H-1B visa category given their pro-offered salary and wage levels. I don't know that we'll see that this time around. Those rules were ultimately not enforceable once it went through the court system. But there are other ways that we expect to see Trump tighten the H-1B program, namely given worksite audits and employer compliance. So kind of related to that, let's shift gears to discuss international students and the critical role of optional practical training, or OPT, with respect to the U.S. talent pipeline. So we may see changes to this program that could ultimately disrupt universities as well as industries dependent on young, skilled talent. Over the last month or so, starting over the holidays, there was a lot of talk about both H-1Bs, but also graduates and university talent, foreign nationals who are attending schools in the US and needing additional talent, particularly in the STEM workforce. So the optional practical training program, OPT, is really important to the US and namely the tech industry. OPT allows international students to work in the US for up to 12 months, and STEM graduates can receive an additional 24-month extension. So this is a good bridge for transitioning foreign national students from education into the workforce. The Trump administration could limit STEM extensions or even eliminate OPT for non-STEM graduates altogether. That would create a gap for industries like business and the arts. Maybe they change what OPT looks like and they do prioritize STEM workers. There's been a push, particularly with Elon Musk and Vivek Ramaswamy, to really help create more opportunities for STEM OPT workers in the United States. So it'll be interesting to see how the chips fall with respect to that issue. And if we do reduce OPT availability, that could definitely lead to fewer international student enrollments, which would weaken a very expensive industry for US universities, right? It's kind of interesting to compare our system to Canada. So Canada offers a much more attractive post-graduation work program. They also function on a merit-based immigration system. There's a lot of other immigration-related issues with Canada that are kind of the topic for discussion another day. But Canada definitely has capitalized in the past off of the lack of opportunities for foreign graduates to stay in the United States. So we definitely want to help keep that talent here. Losing OPT and STEM OPT as a recruitment pipeline would mean greater reliance on other more restricted categories than the H-1B. Like there aren't a ton of options under the employment-based system. So we're going to be holding our breath to see what sorts of changes we see there. Moving on to topic number 3, potential reduction in legal immigration levels. So right now we have a family-based and an employment-based green card system. We have our humanitarian paths to getting a green card as well, but for purposes of today's Facebook Live, let's start with the numbers on family and employment-based. Right now, we have about 226,000 green cards reserved for family-based immigrants, compared to 140,000 for employment-based categories. So our system, as it currently stands, definitely prioritizes family-based immigration. Maybe we'll see a shift in that balance under the Trump administration. There's been some conversations about changing the way that the government allocates those numbers. Right now, we have a system, we refer to that as the Visa Bulletin, which basically shares how the government is allocating green card numbers under both the employment and family-based system for different sponsorship categories. The way that this system is set out has created a very long backlog for foreign nationals from India and China. And there's been some discussion on how we could possibly alleviate that backlog. We'll see how the chips fall on that. But this is more than just a numbers game. We are balancing 2 vital pillars of immigration, family and the economy. And so it'll be interesting to see how the government may or may not address any changes to that system. And then finally, let's talk about enforcement. I already touched a little bit on compliance, but again, we really want to emphasize, particularly for employers, how incredibly important compliance will be under the Trump administration, especially when you sponsor foreign workers. So we definitely are encouraging clients to make sure that they have their Form I-9s in order. An I-9 is given to a new hire for your company, U.S. citizens and foreign nationals alike, and it proves that the individual is authorized to work in the United States. So make sure you're doing internal audits of your I-9s, particularly for industries with compliance risks or not high non-compliance risks like hospitality and agriculture, sometimes manufacturing. So HR, if you're listening, make sure you have your I-9 audits ready to go. We also may see a nationwide e-verify mandate that could require all U.S. employers to verify every new hire's work through the e-verify system. Right now, e-verify is optional for U.S. employers unless you're engaged in government contracts, but it is another layer of oversight, and that may become mandatory under the Trump administration. We'll see. Penalties for non-compliance on I-9s are pretty high. It can be hundreds of thousands of dollars for egregious violations, potential criminal charges. So it's not something to mess around with. And we definitely recommend that employers who do have maybe not the strongest practices, that they conduct internal audits, provide compliance training, and engage even legal counsel to stay ahead of their I-9 enforcement and compliance. So we'll see lots of variables to come, and we thank you for tuning in. We'll be watching this closely. Follow us on LinkedIn, Facebook, all of our social media channels. All of our lawyers are very busy posting and keeping all of you up to speed on what's to come, and thanks for following along.